Hi, this is Brian Ka with another video to help you pass the California Baby Bar and the California Bar Exam. So we're going to do another wills and trusts question, and this is from February of 2016, question 1. So as usual, we're going to read the call of the question, and number 1 call of the question says, what interests, if any, do Dot, Sam, or Bob have in the house and the ranch? Right? Dot, Sam, Bob. Number 2 is what duties, if any, has Sam violated as trustee of the testamentary trust, and what remedies, if any, does Bob have against him? Um, Sam's violation as a trustee and remedies. Right? That's number 2. Okay, so let's read the fact pattern and see what they say. So Wendy is a widow, owned a house in the city and a ranch in the country. She created a valid intervivos trust, naming herself and her daughter Dot as co-trustees, and providing that she had the power to revoke or amend the trust at any time in writing by a document signed by her and delivered to her and Dot as co-trustees. At Wendy's death, Dot was to become the sole trustee and was directed to hold the assets in trust for the benefit of Wendy's sister, Sis, until Sis's death. At Sis's death, the trust was to terminate and all assets be distributed to Dot. The sole asset in the trust was Wendy's ranch. Okay, so they said it was a valid inter vivos trust, a living trust. And to quickly go over what constitutes as a valid trust is you need beneficiaries, beneficiaries, you need a settler, you need trustees, you need trust rest, and you need valid trust purpose, right? Which is not illegal. Okay, so although they said this was a valid inter vivos trust, I feel like the way they're kind of describing to us, who was the trustees and who was going to be um, holding the trust uh, after someone's death and all that. I think that just very briefly, I think it would help to just mention what's really going on here. So here, the beneficiaries are Sis and remainder Dot, right? And Dot is a vested remainder because she is ascertainable and there are no conditions existing here to make her the uh, vested remainder. I think this concept was from real property, and I feel like this question sort of mixes up a lot of real property concepts So I think that it would help if you have taken real property. I've taken it, but I forgot a lot of it already. But I do sort of remember the concepts of shifting executory interests, present, future, you know, vested remainders. Uh, at the conclusion of a life estate, the person who has a future interest uh, is a remainder, but if the person is ascertainable and there are no preconditions existing, then it becomes a vested remainder, and that's who dot is, right? So settler is Wendy. Trustees, um, here it says Wendy and dot co-trustees. Wendy plus dot, right? The trust rest. What's the asset? Here we have the ranch. So valid trust purpose was to basically pay out, uh, you know, the the trust rests to Sis, and when Sis dies, then the trust was to terminate and all assets be distributed to Dot. So it was for distribution of assets, and that's obviously not illegal. So we do have a valid intervivos trust, right? Valid intervivos trust. There's no argument that it wasn't. They even tell us that it was valid. So since it was valid, usually I don't talk about this at all, but that would depend on the facts because this is very fact heavy, and the reason why they're probably giving us this is for us to just quickly go through it and say, hey, you even mentioned that this was valid. I even did a little checklist here and I went through it, and it seems like this was totally a valid interviewer's trust, right? So after years later, Wendy prepared a valid will in which she stated, I hereby revoke the trust I previously established and leave my house and ranch to my son Sam as trustee to be held in trust for the benefit of my brother Bob. 5 years after my death, the trust shall terminate, and all assets then remaining in the trust shall be distributed outright to Sam. Okay, so we're dealing with trust revocation, right? Now, I think it's very important not to confuse this with will revocation, right? Because for will revocations, there's got to be intent and physical act, right? Intent plus physical act. And that physical act can be anything from like tearing up, burning, canceling, obliterating, destroying, blah, 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 blah. Same thing. But since we're not dealing with a will revocation, but a trust revocation, the rule for trust revocation is usually it's revocation by it's the revocation is dictated by the language in the trust, right? Unless there's clear intent plus writing, right? Um, but this number one seems to be the majority rule. So we're going to follow uh, this first majority rule, which requires that the revocation follow the terms of the actual trust, and the way the way revocation is done is only through how the term dictates, how the trust dictates how to revocate this trust. So here, the language here says, Dot as co-trustees and providing that she had the power to revoke or amend the trust at any time in writing. So the language was anytime, um, anytime in writing, right? And here it says Wendy prepared a valid will in which she stated, right? So it seems like it was in writing. Now, um, this trust uh, said that the that Wendy had a power to revoke or amend the trust at any time in writing by a document signed by her and delivered to her and Dot as co-trustees. So it had to be in writing, had to be signed, right? Uh, but the signing requirement and delivery instructions required that both Wendy and Dot sign it and get it delivered. Now here, uh, when Wendy prepared a valid will, she said that she revoked the trust she previously established, leave my house and ranch to my son Sam as trustee to be held in trust for the benefit of my brother Bob. And 5 years after my death, the trust shall terminate, and all assets then remaining in the trust shall be distributed outright to Sam. Okay, so here it seems like there was an agreement by Wendy to revoke, but because the terms of the trust dictate how this is revoked, and since the original trust required both Wendy and Dot to uh, get the revocation in writing and signed, and since Dot never received the revocation and didn't sign, does that leave this revocation valid or invalid? Obviously, this revocation attempt is not valid. So, number two, we can say that the trust here, this uh, will here, will does not, a second will does not revoke the trust due to failing the requirements on how to revoke, right? Now, when you look at the second paragraph, it talks about how uh, I leave the house and ranch to my son as trustee to be held in trust for the benefit of my brother Bob. So she created a will, right? The revocation is not valid, but the thing about this will is that she wanted the um, let's see here. She wanted the house and ranch, right, to be distributed, right, um, or go into the trust, right, on Wendy's death, which means that this was a testamentary trust because this trust becomes active when Wendy's dead, and this was since the will wanted the house and ranch go into the trust. This would be a pour over will, right? Because here the facts tell us that the house and ranch to be held in trust for the benefit of my brother Bob, right? So this was a pour over will, but since this included both house and ranch, and this original trust included the sole asset, which was the ranch, the ranch cannot be willed, but however, this house um, will be distributed, and how it's going to be distributed is by the language. And here it says Bob has possessory interest, right? And uh, after 5 years of Wendy's death, this house goes to Sam, right? So Sam has a executory interest, which basically cuts off the previous grantee, who was Bob, right, upon a condition which was 5 years after Wendy's death, right? So this was a shifting executory interest, and Sam doesn't have uh, no present possessory interest, but shifting uh, executory interest 5 years after um, after Wendy's death. So we figured out um, that here, because Ranch was already was gonna go to Dot, this house gets distributed to Sam, but for now Bob has the present possessory interest, but this present possessory interest gets cut upon a condition, which is Wendy's death. Uh, so 5 years after Wendy's death, Bob, Sam gets this house, right? And that's how you distribute the house between Bob and Sam. And again, Dot ends up with the ranch because this revocation, which required a sign by Dot and Wendy, was not fulfilled. Therefore, the original language for what goes to Dot still controls. So, since the original language said once the trust was to terminate and all assets distributed to Dot, um, once Sis dies, the trust terminates and goes to Dot. So Dot and Sam doesn't have current possessory interest, but when Sis dies, she gets the ranch. Here we talked about this already. Bob has possessory interest, but Sam has the executory interest, meaning once there is a condition that's triggered, uh, this executory interest means this house shifts back to Sam, and Bob no longer owns the house, which is 5 years after Wendy's death. So here we already distributed Dot and Sam and Bob. We talked about valid intervivos trust. We recognize that trust revocation is different from will revocation, um, which was kind of tricky. I think that the most tricky part for this first call of the question was that there are two trust rests that we had to decide on how to distribute. And unless you read carefully, you could have easily mixed this up. But since the first trust wasn't revoked, uh, the language of the first trust controlled, but that language only contained uh, the ranch as the trust rests. So ranch follows the language of the original trust. The second, the revocation, although it wasn't valid as a revocation, it was actually valid. I mean, it was valid as a will, right? So although it didn't revoke who owns the ranch, the house itself was going to be distributed, and it was going to go to Bob for until Wendy dies, and 5 years after Wendy dies, it was going to go to Sam. So that was really complicated, but that's how it goes. So, what duties, if any, has Sam violated as trustee of the testamentary trust, and what remedies, if any, does Bob have against him? Okay, so what did Sam do? I mean, okay, Sam do. Sam has agreed to serve as trustee under the testamentary trust and claims that the ranch is part of the trust. Sam then sells the house at a fair market price to himself in his individual capacity and invests all the assets of the trust into his new business, Sam's Solar. Bob objects to sale of the house and to Sam's investment. Okay, so when you talk about trustee duties, we've done this so many times now. Trustee duties or duties of trustee. On top of my head, you have a duty to be impartial, right? You have duty of loyalty, duty of care, and this is reasonably prudent person, right, or investor. Duty of loyalty, impartiality, duty of care, and duty to follow instructions, right? And sometimes some model answers it talks about accounting and maybe two or three more things. I think these four things would basically cover it, and I think for me, I think it's good enough. Um, Here, we're going to have to go through each element and prove that either Sam did he violate his duties as a trustee. Here, the main thing is that Sam sold the house at a fair market price to himself in his individual capacity and invested all the assets of the trust into his new business, right? So even if we assume that he was being impartial or whatnot, there's definitely a breach of duty of loyalty. There is no self dealing. That's the language, right? Here he clearly self dealt. Duty of care as a reasonable, prudent investor or person. No reasonable person would um, uh, not follow the instructions, which is number four of the trust language, and um, place all the investments into the trustee's own business, right? That is a violation of maybe all of them, if you can argue it. And definitely, I'm not going to get into back and forth because that's not too hard. um, the point of this video is to show you how to organize these essays. So, uh, duty of impartiality, duty of loyalty, duty of care as a reasonable, prudent investor, duty to follow instructions and in accounting, you know, probably violated all that. So here, he failed to act as uh, a or breach. He breached his duty as a trustee. Now, the second part of the second call of the question is what remedies, right? And when you talk about remedies, it's usually for trustee duties, it's three things: disgorgement, surcharge, and termination of trustee position, right? Disgorgement is if you gained anything from this scheme, he has to spit it back, any profits. Now, a surcharge, it doesn't have to be um, any kind of profits he made, but if he lost money as a result of being a trustee here, he's even going to have to spit it out of his own pocket. That's probably worse. Now, lastly, um, they're going to seek to remove him as a trustee. And for the second part of number two, after you go through the breach of duties of a trustee analysis, you're going to talk about disgorgement, you're going to talk about surcharge, and you're going to talk about how they're going to try to remove him as a trustee in this case. So, yeah, this question again, the second part was fairly easy, but I think what made this question hard is that you could have used just plain language, but there are a lot of real property overlaps because um, there was a life estate and there was like a remainder, there was a vested remainder, contingent remainder. You have to know what a vested remainder is. Um, Also, there was a shifting executory interest. Um, you know, it's like a future interest that cuts short of a prior interest upon a condition, right? And things like that was what made it a little bit complicated because if you haven't taken real property, these concepts may sound new to you, and if even if you had taken it like me, it's been a while, so I had to kind of review these in my mind and make sure to go through them again and use them. But yeah, this again, I find that wills and trusts essays are pretty hard. I would say that they're even harder than community property, for me at least. Definitely harder than uh, torts contracts and criminal law. Not sure if it's harder than real property because real property was so vast. But since this question was kind of linking back to real property, that's what made it a little bit difficult. But difficult doesn't mean that it's not doable. And I think that with enough practice, you could have outline this correctly and recognize that there was a huge trust revocation issue and that it's easy to mix up trust revocation and will revocation. And I think this was a good practice to remind yourself of how to revoke a trust or how one can revoke a trust versus revoking a will. So with that, I thank you for watching another video, and I'll talk to you next time.